that most people got asked, and there's a lot of people that are in favor of medical marijuana. I certainly understand that. You're about to get an opportunity to vote on an alternative that will be a true medical marijuana program if the voters enact it come November. However, Initiative 65, and again, not are you in favor of medical marijuana, but the actual language that will go into the Constitution should Initiative 65 pass, is extremely problematic. It's a far overreach of what we ought to be placing into our Constitution, and it turns our constitutional framework on its head as follows. Initiative 65, right out of the gate, would change the Constitution to initially give all caregivers, physicians, and anyone in the marijuana business, now think about that for a minute, anyone in the marijuana business are going to be completely exempt under the Constitution from any and all civil and criminal liability from this point forward. I bet most people who signed that petition did not realize that. People who sell other drugs all over the place are not exempt under our Constitution from civil and criminal liability. Think about that. That's a major, major overreach. Is that really what you want to go home and explain to your constituents, that we allowed that to happen? That when someone overdoses because they got a physician prescribed them up to 300 marijuana joints in 1 month, and they decided they're going to smoke all 300, and they died, that there's no liability for that whatsoever? Think about that for a minute. That's what this initiative will do. I'll continue my explanation as follows. In addition to that, it's going to provide, set into our Constitution, that when someone is caught, it is illegal to smoke marijuana publicly, okay? But it provides that when someone is caught smoking marijuana publicly, they can be out here on the front steps of the Capitol with a bong, and from this point forward in our Constitution shall receive no more than a $100 civil penalty, $100 fine. That's all they got. That's all they got. Are you aware that most speeding tickets are more than $100?
Maintain order.
This is serious business, guys. This isn't anything to laugh and smile and clap about at this point in time. This is serious. We're going to set in our Constitution that smoking a federal illegal drug is capped at a $100 fine. That's it. Is that what you want? Next, it further defines many medical diagnoses in the wording, but it defines them very broadly. Also includes catch-all language that says, after it defines and lists 22, of which chronic pain is one. What is that? There's many episodes of real legitimate chronic pain. There's also episodes of someone's, it's subjective totally to that physician. Let me continue. Are you aware that under this language it will not preclude the doctor who prescribes the marijuana from also being the doctor who finds the diagnosis? So what's that going to encourage? Anybody ever heard of doctor shopping? It goes on. Who's going to pay for when a person shows up at their doctor's office wanting a diagnosis of chronic pain or some other similar type diagnosis, as the language reads, totally subjective to that physician? Who's going to pay for that? Your insurance company, my insurance company, Medicare, Medicaid. That's who's going to pay for that. Then they're simply going to take that medical record and go over to their marijuana doctor and say, here's my diagnosis, give me my marijuana. Were you further aware that the language that's going to go into that would go into the Constitution under Initiative 65 exempts all records whatsoever from public disclosure under the Public Records Act? I'm not a doctor, but if I'm on the board of medical licensure and I'm in charge of licensing doctors, to me that's a real problem, because I have no access to what doctors are doing that I license and I regulate. Are you aware that there's only one license, one permit will be given out for any aspect of the marijuana business? Whether you cultivating the seed, plowing the ground, transporting the product, dispensing it, whether you're giving it, you're the caregiver. Any aspect, marketing, one license. Did you know there's no regulation whatsoever in the language about how many licenses that will be given out? There's a similar state in Oklahoma that has over 10,000 marijuana licenses. How do you think the State Department of Health is going to properly regulate that amount of licenses for people in the marijuana business? I'm going to go ahead and tell you they're not. Not because they're not capable, because they physically can't. They're physically not going to be able to do that. So what's that going to cost? You do have a legitimate condition. You go to your doctor, you get a legitimate prescription for medical marijuana. What's that? Does that doctor have any reliable, is he going to be able to rely on the fact that the script that he actually writes is going to be what you actually ingest into your body? No. Why? Because it's not going to be properly regulated. Because somebody over here on the other side growing some really high-end stuff, THC levels are going to be totally different in those two items. But when that doctor writes that script, that doctor has no idea, cannot reasonably rely on the level of THC that's going to be placed into that individual's body. Okay, that's different. When I go to the doctor right now and I'm sick, that doctor writes me a 500 milligram script for an antibiotic. That doctor, because of the regulatory scheme we have in place right now through FDA, he can rely, or she can rely, that I'm going to actually get 500 milligrams of that particular drug. Under this program, it's not going to be so. Let me ask you this. Were you aware that under this program, once you get a script for medical marijuana, it's good for a year? Did you know how much marijuana you can get? Specifically state, and will state in our Constitution if it passes, 2.5 ounces every 14 days. Let's just say 5 ounces every 28 days or 5 ounces a month. Y'all know how much weed that is? 300 joints a month. 300 joints, marijuana joints a month. Let's say somebody smokes 3 joints a day, okay? For an entire month. At the end of the month, they've got 200 joints left. Where's that? What's going to happen to that weed? So when I tell you this language is just one step removed from straight up recreational marijuana, that's what I mean. The intent of this language is to totally flood the market of this state with marijuana. It's a major overreach, and it's not what the individuals who signed up for this thought they were signing. There's a reason, ladies and gentlemen, and I want you to hear me very close. I went on this week, yesterday, I went on the website for Medical Marijuana 2020, and I looked for a lot of things, studied it, but I looked for the language that will go into the Constitution on their own website. And guess what? Nowhere to be found. Didn't find it. It's not on the website. Why is it not on the website? Because are you for medical marijuana sounds good, and most people probably are for some version of medical marijuana. But what they have put forward, the language that will actually go into the Constitution, is not that. It's something entirely different. Let me talk to you about something that I believe turns the Constitution on its head. Not to mention the fact that I personally believe marijuana going into our Constitution trivializes our Constitution. We don't have any other drug in our Constitution. We don't have alcohol in our Constitution. But let me talk to you about something else entirely. This language that's being proposed totally removes the taxing and appropriation authority from this body, from the very branch legislative branch that we're sitting in right now, and it hands it to an executive state agency. The lawyers in this room can understand, with me, the problems that causes. That goes totally against the constitutional framework that we have relied upon for so long. It's the legislature's job to tax. It's the legislature's job to appropriate. It's not the executive branch's job to do those things. This language caps the tax on this so-called medical marijuana at no more than the sales tax rate. Well, what is the sales tax rate? I stand here before you as the Ways and Means Chairman. I'm telling you, we got a bunch of them. We got a 7% rate, we got a 5% rate, we got a 3% rate, and a 1.5% rate. We also got a 0% rate. But what we do know is that it can be no more than 7, which is our highest sales tax rate. Well, where does that money go? Let's say they set the sales tax rate, and this will be decided by the Department of Health, by the way. This body has nothing to do with it. Nothing. But let's say they set it at 7%. Where does the money actually go? Does it come to this body to be used on education or law enforcement? Because we know we're going to need more money in law enforcement if this one notch below recreational marijuana passes. Where's it go? I'll tell you where it goes. It goes into a cycle. It goes into a fund at the Department of Health that can only be spent by the Department of Health in furtherance of the marijuana program. That's what it does. So all money that comes in off the little taxes that will be implemented on it can only be spent for more marijuana. Think about that for a minute. Is that what your constituents expect out of a medical marijuana program? How many times have you heard back home that we need to use this money for law enforcement, or you need to use this money for education or roads and bridges or things of that nature that are important to this body and important to moving this state forward? Well, this would be in our Constitution that we can't do those things. Let me tell you something else that it does. And I had to read this not once or twice, but multiple times before I actually believed that this was in the language. This proposal would completely and utterly exempt anyone tied to any portion of the marijuana business from your local zoning ordinances. Go back home and explain that to your mayor when the pot shop comes up next to your courthouse downtown on Main Street. You gonna say you allowed for a pot shop to be the main focal point of your Main Street back home? Maybe you want that. I don't. My people back home don't want that. It exempts in our Constitution anyone related in any way tied to this business from your local zoning ordinances. Have fun explaining that to your neighbor when the weed farm ends up next door to their house or their neighborhood. That's what this does. You need to know what you're voting on, ladies and gentlemen, because what has been sold to you is not so. This is not simply a medical marijuana program. This is, as I said before, just a step below straight up recreational marijuana. It's designed to flood the market with marijuana that will lead this state into a recreational marijuana environment. So, it's not as simple as are you in favor of medical marijuana or not. Now, what does HCR39 say? This is the alternate. HCR39. It's not a complicated document. It's been on the website for weeks, right here. Not hidden. It's been on our website for weeks. I hope you've read it. I'm going to tell you what it does. It simply states, there is established a program in the state of Mississippi to allow the medical use of marijuana products by qualified persons. Did y'all hear that? There is established. This is not an effort to kill it. It says there is established. People will get a chance to vote on that. The program shall be based on sound medical principles. The administering agency shall seek the input of health professionals to help design the program, and it will be limited to qualified persons with debilitating medical conditions. To me, that sounds like a real medical marijuana program. Also goes on to state that marijuana products shall be of suitable pharmaceutical quality and prepared by state licensed manufacturers. You see there? There's that regulatory authority that the other language does not want. It's important, and it's important for a reason. Goes on to state that the program shall provide for categories of marijuana preparation of suitable and verified quality standards for oral administration, and the smoking of marijuana will be limited to terminally ill patients. There's not a doctor that walks around in this country that'll tell you smoking anything in any form is good for you. Now, if you're terminally ill, that's a different case. Doesn't matter if you're smoking a bamboo shoot. It's not good for you. Doesn't matter. Smoking, inhaling smoke into your lungs is not healthy. And any doctor worth his salt is going to tell you that. Goes on to state that the program shall have a limited number of manufacturers, shall have a patient registry for program enrollment, patient tracking, and treatment outcomes so that we can determine, the public can determine if this is a successful program or not. Totally different than their language, okay? Where they exempt all records from public disclosure. Also shall provide reporting requirements that includes research, analysis, and outcomes-based assessment. Pretty simple, pretty straightforward. Said we will have a program. Ladies and gentlemen, I submit to you that the people who signed this initiative were sold. They were sold on, are you in favor of a medical marijuana program? If you are in favor of a medical marijuana program and you think that that would be a good thing for this state, which I tend to believe it would, properly done, then you need to vote for HCR39. If you want something that is a step below straight up recreational marijuana and that will lead this state into the future with that endeavor, vote against HCR39. Those are your options. That's my explanation.
Questions. Lady from Lincoln, Ms. Curry.
Thank you, Mr. Speaker. Would the gentleman yield?
Do you yield, gentlemen?
Yes.
Thank
Yes.
you. So one of my concerns with this alternative, and I just want to ask you, because when we talked about it in rules, there was something that the doctor who wrote the prescription for marijuana was going to be turned over to the Board of Medical Licensure. Is that correct?
I didn't understand your question, lady. Can you repeat that?
Sure. So a doctor who writes a prescription, because you have to have a prescription to get marijuana, that doctor would be turned over to the Board of Medical Licensure. Is that correct?
Under which proposal? What are you talking about?
Under yours.
HCR39?
Yes, sir.
That's not my understanding, no.
Okay, because you had said that the Board of Medical Licensure needed to know what doctors were doing, and I'm just saying right now they can write you a prescription for oxycodone and they're not turned over to the Board of Medical Licensure, but you were talking about turning this position over to the board. So
no,
that's why
I wasn't talking about turning it over. The point I was making, and it goes to the regulatory scheme, and oxycodone is highly regulated through
Yes.
FDA. This will not be regulated like that, such that a doctor will not be able to reliably rely on, when they give that person that script for marijuana, going to have no idea what level of THC concentration that patient of theirs is actually getting.
Yes, sir.
That's the difference.
Gentleman from Washington, Mr. Hines.
Speak on the bill.
Okay. Gentleman from Harrison, Mr. Felcher.
Gentleman yield?
Sure.
Two questions. One, if this drug is prohibited by federal law, how is the state going to transact in funds?
That's a good question. I can tell you there's several other states that have a program, 30-something is my understanding. And in those states, they get creative. But if the federal government ever decides that it wants to crack down on its laws, enforce its laws, then obviously they have the legal authority to do that.
Second question is, in Initiative 65, I believe there's a date spelled out for a timetable for licenses to be issued.
Yeah.
With the HCR39, will we have a time frame where people with cancer and whatnot can be ensured that we're working on this and it's going to be a real thing?
Gentlemen, here's
Thank you,
what I
sir.
can tell you. It's written and designed to be a real thing. Let me tell you, I'll just read the language to you again, because the language speaks it best. It says, there is established Also says shall be established, okay? If the Constitution says the state of Mississippi shall do something, we got to do it, okay? We got to do it. And any Tom, Dick, and Harry that can find a lawyer that's worth his salt can file suit against the state of Mississippi to enforce that provision in the Constitution should this body fail to act. Thank you.
Gentleman from Madison, Mr. Bumgar.
Thank you, Mr. Speaker. Does the gentleman yield?
Sure.
Gentlemen, did I call you about Initiative 65?
On the telephone,
Yes, sir.
we had a conversation about Initiative 65 maybe sometime last year.
Gentlemen, do you remember how long ago that conversation first was?
Sometime last year.
Gentlemen, it wasn't last year. It was not in 2019. Do you remember when that might have been?
I don't, but if you want to tell me, I'll be happy to
Well,
listen.
gentlemen, it was spring and summer of 2018.
Okay.
Back when Initiative 65 was being drafted. Gentlemen, my question at the time, do you remember what I asked you on the phone back in summer of 2018, more than 18 months ago?
Well, I can't quote verbatim, gentlemen, but one of the things you asked me is, are you generally in favor of a medical marijuana program? And I told you straight up, I could see where it would be beneficial. So, yes, I was in favor of a medical marijuana program. What you didn't ever tell me or show me was the language that you were proposing put in our Constitution. Not once did you ever send it to me, talk to me about it, or have any conversation whatsoever with me about the language that you want to go into the state's Constitution.
Gentlemen, did I ask you to serve on the committee to draft the initiative?
And did I not tell you no?
You told me no, gentlemen. You told me you did not want to be part of the committee to help draft the initiative. Now, gentlemen, if you care about medical marijuana and you apparently care strongly about what this is, why 18 months ago, when you were asked to serve on the committee to draft Initiative 65 that was going to get signed by 228,000 people, did you tell me you weren't even interested in serving on the committee to help draft it? Why, gentlemen?
Because I wasn't interested in serving on a committee.
You're right, gentlemen. You didn't care back when it was the time to actually do that. You had no interest in helping draft it. And so here you are with an alternative. The question is, how am I supposed to get input from people like you if you refuse to serve on a committee back at the beginning of the drafting process?
Gentlemen, let's be clear here, okay? You're a smart man, okay? And you've got enough money where you hire really smart lawyers. You do not need my input. Your language in Initiative 65 is exactly what you wanted and exactly what you paid a lawyer a whole lot of money to draft for you, okay? Don't act like you needed my participation.
Gentlemen, I wanted your participation so that the people of Mississippi could have a fair up or down vote in November. And had you participated, we could have come up with something that you and I agreed on. Gentlemen, why did you not want to participate in that? If you didn't like the way it was going, you could have said, hey, I'm opposed to this, I'm going to have an alternative amendment. But you say, look, I don't want to sit at the table, draft it without me.
Gentlemen, this is your passion, okay? It's not my passion. Don't hold that against me. I got baseball games to coach, football games to coach. I got a wife to be a husband to. I got a busy law practice. I didn't have time, nor did I want to serve on your committee. Simple as that.
Well, gentlemen, you're spending way more time coming up with this alternative and whipping votes and all that than it would have taken for you to provide a few highlights back 18 months ago that would have made the whole thing more to your liking.
Gentlemen, I would have, if I would have served on your committee, it would have been something similar to HCR39, and I'm not a predictor of the future, but what I can tell you is, with almost certainty, you would have said, not no, but no, okay? We ain't doing that, because you have developed the perfect libertarian policy. You've thought of everything you think you can think of to put in our Constitution so this body can never touch it. You've turned the Constitution on its head. You've taken away the taxing authority and the appropriating authority from this body. That's unconstitutional in and of itself.
Gentlemen, the drafting process was done. The people that were involved, the people who did sit at the table, involved the Department of Health, the Mississippi State Medical Association, the Speaker, Governor, Lieutenant Governor, Secretary of State, Attorney General, all got copies of the initiative with requests for comment, with requests for feedback. All of those entities. Gentlemen, you're saying this is my deal. 75 people on the steering committee, including more than a dozen medical doctors, got the language. They got revisions of the language. They got drafts of the language. The chiefs of staff of all the people I just mentioned all got copies of the initiative. How, gentlemen, does that make it my deal?
Gentlemen, everybody knows this is your deal.
Gentlemen, I'm passionate about it. There's a huge group of people. There's 228,000 people that are passionate about this.
Well, they may be passionate about a true medical marijuana program, but I'll just go ahead and say, most of them don't have a clue what you're offering to put in our Constitution.
Well, gentlemen, has this chamber ever tried to do a medical marijuana program in the past?
Not since I've been here.
Well, gentlemen, are you aware of the CBD program that exists at UMC today?
Yeah, I voted for it.
Well, gentlemen, how many people have ever benefited from that program since it was put in place 6 years ago?
Why don't you tell us?
Well, gentlemen, it's 8. 8, gentlemen. My question, gentlemen, how do you believe that what you've drafted here is going to result in more than 8 people benefiting? In fact, by my reading of it, you could literally walk in here in 2021 with a one-sentence bill that says, we hereby name the CBD oil program at UMC, the medical marijuana program of Mississippi. It meets all your requirements and you're done. 8 people, gentlemen. How are we not expected when the legislature's already had a chance to do this and the program that was put together resulted in 8 people after 6 years? And gentlemen, what's the name of that program?
Gentlemen, the CBD program that you're referring to is not this. Those are totally separate deals, totally separate. That was highly regulated, highly limited, and this is not that. You're trying to equate apples and oranges, and it's not the case. This HCR39 would put language into our Constitution that there shall be a medical marijuana program developed by doctors. So the very ones that you're talking about that you put on your steering committee that you say are so passionate about this, we'll get to draft the rules and regulations, okay? But you know what? Most doctors don't understand constitutional law, and they probably don't really understand what you did with this language. It's a major overreach, and if you wanted a true medical marijuana program for this state, you shouldn't have done that. You shouldn't have overreached that way.
Gentlemen, if you wanted a true medical marijuana program for the state of Mississippi, you should have served on the steering committee 18 months ago when you were asked. But gentlemen, here's my question. The program at UMC, how does it not meet the requirements of your bill?
It doesn't, gentlemen.
How not?
It's a totally different deal.
It's not a totally different deal, gentlemen. If you rename that program the medical marijuana program of Mississippi, how does it not meet every single requirement in your bill today?
Give me read it to you again.
No, gentlemen, I want you to answer the question, which is how does it not check every box you've laid out here?
Because it doesn't.
How does it not? It checks every single box in your bill, gentlemen. Okay. And so why are we to believe that if there's already a program that is not really medical marijuana that checks all those boxes, that this is going to be any different?
Because the very reason you just said, gentlemen, it's not medical marijuana. And this constitutional amendment that we are altering says there shall be a medical marijuana program, and anybody with any good common sense can see the difference in the two.
No, gentlemen, because CBD oil is an extract from medical marijuana. But gentlemen, what's that program called?
Tell me, I don't know.
Is it was it created by Harper Grace's law?
My understanding, gentlemen, is there is someone it's named after, but I couldn't speak to it because I haven't studied that. That was done probably 7 or 8 years ago, and I have no idea who it's named after.
Well, gentlemen, it's named after Harper Grace Derval. It's named after her because she has Dravet syndrome. And gentlemen, do you think she's part of her own program?
Gentlemen, I am no expert in that particular individual's care.
Well, gentlemen,
I can't answer those questions.
Would you say if a program is passed in the name of Harper Grace Derval, and then that program is set in place, and Harper Grace Derval is not allowed to participate in her own program, would you call that a success?
Gentlemen, I don't have any knowledge of what you're talking about. That is not this. Again, you're trying to compare apples and oranges. It's not the same thing. It's totally different.
There's no reason that everything that is in that program would not check the boxes you have. And there's no reason. So gentlemen, if you're passionate.
Are you letting 8-year-olds and children smoke marijuana in that program? I don't think that's happening, is it? Because this provision says that terminally ill patients will get to smoke marijuana. Okay? It's going to say it. It's right here. You can read it. It's not the same thing.
Gentlemen, there's no reason to believe over the last 6 years, and gentlemen, if you are passionate about this issue or cared about it, why haven't we done anything in this legislature until 228,000 people signed the initiative?
Gentlemen, you're to be commended for getting people to sign the initiative. But I don't agree with what you've done with the language to our Constitution. And I submit to you, most people, if they knew it and understood it, would not agree either.
Gentlemen, I don't think if anybody saw the program that what you are proposing would actually create would sign that either, gentlemen. That is not going to create a program that benefits enough people to matter. But gentlemen, okay, you talked about the website, gentlemen. The initiative, if anybody wants it, is on the download section. You click on the download section, and it's the very first link. Very first link, ladies and gentlemen.
Sure not easily findable, I can
Now,
tell you
gentlemen,
that.
well, I'll leave that to you, gentlemen. Gentlemen, in your discussions for the little group of y'all that got together to do this, were there discussions about the fact that this may actually kill both initiatives?
Gentlemen, let me tell you what might kill your initiative is if not enough people vote for it, okay? The people are going to get to decide this. Not you, not me, the people.
Gentlemen, I asked you a question. Was there a discussion in your group about how this alternative may kill both initiatives?
No. The people deserve, gentlemen, what you don't realize is the people deserve to be able to vote on a real medical marijuana program, not one step removed from recreational marijuana, which is what you have proposed. You have told the whole state that we're going to have medical marijuana, okay? But what you haven't told them is that you've overreached entirely and that what you are actually proposing is one step shy of recreational marijuana. You're going to flood the market, and you've got all these exemptions going into our Constitution for this new business venture, and at that point in time, gentlemen, it's not medical marijuana anymore, okay? So what we're giving the people is an opportunity to vote on what you've told them they'd be able to vote on.
So gentlemen, do you claim that this somehow is going to be something other than medical use? Gentlemen, how I'm going to read what I'm holding in a second here, but gentlemen, how many times does HCR39 mention the word regulate or regulation?
I haven't counted the words. You can read it just like I can.
It's 0, gentlemen. 0. Your initiative doesn't include the word regulation or regulations anywhere in it that I can tell, or that my keyword search is exposed to me. Gentlemen, Initiative 65 has 19 instances of the word regulate. But gentlemen, here's my question, gentlemen. Initiative 65, is there a portion of Initiative 65 that says nothing in this article shall affect or repeal laws relating to the use of marijuana that is not intended for debilitating medical conditions? Does Initiative 65 say that?
Say that again.
Gentlemen, does Initiative 65 state
maybe if you could tell me where on your 7-page constitutional amendment you're reading from that I could get there?
Well, gentlemen, it's 5, but gentlemen, Section 3. Nothing in this article shall affect or repeal laws relating to the use of marijuana that is not intended for a debilitating medical condition, and nothing in this article shall authorize the use of medical marijuana for anyone other than a qualified patient. And gentlemen, Section 4 defines a qualified patient, and it defines debilitating medical conditions, and it lists a list of conditions. Now, how is that anything other than medical use?
It does say that, gentlemen. I mean,
okay, well, gentlemen, so gentlemen, where in here is recreational use?
Were you in here when I explained the bill?
I was in here when you yes, gentlemen, but I want you to point me to the exact section where it actually says someone who you can use it for reasons that are not medical.
300 joints a month. Really?
Gentlemen, that's not as many as it is. And gentlemen,
let me hate you. That's not Trey Lamar's language, okay? That came from a gentleman named Mr. Larry Walker, who is the head of the marijuana program at Ole Miss. And I said, gentlemen, I'm no expert on this when I started studying it. Tell me how much 5 ounces of marijuana is.
Gentlemen,
and that came from him. A lot more knowledge than me.
Do you know where 2.5 ounces every 14 days come from? His program, gentlemen. It came from his program. That is their federal standard. And that standard was set consistent with the federal standard at Ole Miss.
Well, would you be surprised to know that he is not in favor of this, your language at all?
Well, gentlemen, he was one of the many groups that we went and visited and invited feedback on. So, okay. You know, just like you, gentlemen, there was a time for input, and it was about 18 months ago.
Gentlemen, let me ask you this. Is it or is it not the legal prerogative of this body to offer an amendment when we see fit? Or an alternate language when we see fit?
Yes, gentlemen.
So you're acting like we've done something nefarious, and I would submit to you that the reason the law reads that way is to prevent overreach, just like what's happened in this case.
Well, gentlemen, from a process perspective, it would have been nice if you had that opinion about 18 months ago. But gentlemen, I just want to be clear, because you didn't really answer a previous question. In the group of the 8 of y'all that came up with, concocted this thing, were there discussions about how HCR39 would actually kill both initiatives?
Well, you're going to have to tell me who the 8 of us are, because I'd have to take myself back to that meeting.
Well, gentlemen, this is the 3rd time you haven't answered the question. Were there discussions, as you all were discussing HCR39?
Gentlemen, let me answer it this way, because I know what you're trying to do is make a point. We have discussed I have with multiple people. That'd be the speaker, that'd be other legislators, that'd be physicians, doctors, people interested all over the place, constituents. I've discussed the possibility of it passing, the possibility of it failing, whether or not we need an alternate or not. I have discussed all of those possibilities. So yes, all of those discussions were had.
And gentlemen, that's a nice way of saying the group of y'all believes that this alternative amendment will kill both of them, and that's the intent.
Absolutely not.
Well, Mr. Speaker, I'd like to speak on the bill at the appropriate time.
Lady from Pearl River, Ms. Wilkes.
Thank you, Mr. Speaker. Gentlemen, will you yield?
Yes, ma'am.
I'd just like to say what a good job you've done on presenting this, and I'd like to say that in lieu of all the other things that we've talked about today, one of the things we haven't mentioned is workforce development, which we've talked a lot about.
Yeah.
This is one step above recreational marijuana. We have a big enough drug problem, and if we pass this with all the concentration we're doing on workforce development, it's going to be detrimental to our economy and not what we want Mississippi to be about. Thank you,
lady.
gentlemen.
Gentleman from Scott, Mr. Miles.
Would the chairman yield?
Yes, sir.
Hey, just a couple questions for point of clarification that you might could help. One of the questions, I think everybody, I wouldn't say everybody, but the majority of the people in this room, you probably believe that they want some kind of medical marijuana for their families when they're
Sure.
sick, in that case, right?
Sure.
Now, one of the questions that keep coming up is dealing with the federal things that my desk mate touched on it a little bit, but was if you were a gun owner and this were to pass, the way in the current language, would that prohibit you from being able to hunt or carry your firearm?
It's a good question. I mean, at the end of the day, gentlemen, marijuana is a scheduled drug under federal law. I mean, if you're, obviously, felons can't own firearms. It's as simple as that.
And then another question that it came up this morning was talking about federal funds for education and that thing. If a teacher were to have a prescription for this medical marijuana, would they still be able to teach because the schools receive federal funds?
That's one of those potential unintended consequences. That would something that would have to be addressed down the road.
Okay. And then another question I had, we're talking about initiatives and things. We had an initiative a few years ago. Do you remember Initiative 42?
I do.
And I was looking at some of the folks that had sponsored in favor of this initiative that's here on the ballot, but I think some of those were also in favor of the alternative on 42A, and now they're not for an initiative. But would you agree with me that it's the responsibility or the legislative's priority, whether if you agree with the initiative or if you want to make it better, that you can offer alternatives?
It is, gentlemen, and maybe I didn't do a good job of making that clear a few minutes ago, but that's certainly, it's not, we don't just have the legal authority to do it, we have the legal responsibility to do that in certain situations when it's appropriate.
And those that are maybe arguing against your initiative that you're proposing today that argued for the initiative on 42A, you think that might be a little hypocritical?
Well, it is what it is, gentlemen.
Thank you, Jim.
Yes, sir.
Lady from Jones, Ms. Scott.
Thank you so much, Mr. Speaker. Will the gentleman yield?
You know what, will, lady?
Thank you so much, gentlemen. Now let's see, can we get a little clarity here? On the proposed amendment, the Initiative 65, I believe, gentlemen, it talks a little bit about who a qualified caregiver would be, who a physician would be, and the medical treatment center. And you represented to the House that if Initiative 65 were adopted, that these people would not be subject to any criminal or civil sanction. Did you not say that, gentlemen?
I did.
Okay, now, gentlemen, what the initiative actually says, and I heard you say you read it, but this is what it says. It's talking about the availability and safe access to medical marijuana for qualified persons with debilitating medical conditions, except as otherwise provided for this article. Only if this initiative becomes law, then a qualified patient or caregiver would not be subject to criminal or civil sanctions. That's what Initiative 65 says. Is that not correct, gentlemen?
Well, certainly.
Is that not correct? Okay.
This would have to
No,
be,
but-
I'm going to
but-
explain my answer, lady. This is not a gotcha situation. I
No,
get to
sir.
explain my answer.
I want you to explain.
I said certainly, but obviously this would have to be adopted and become law for any of that to take effect.
Absolutely, gentlemen.
Yes, ma'am.
That's just like with the amendment, the bill that you had the other day, that I heard you say it was unconstitutional for us to give away our bonding authority, and you came up and passed a bill to give MDA 50, 60, $100 million worth of bonding authority that doesn't come through this body. But anyway, that's another subject for debate for another day. So that the House understands, if this does not become law, then the people would not be under this criminal or civil sanction elimination. That's correct, isn't it, gentlemen?
Sure.
And the way you explained it to the House, it was just like, regardless, they would not be subject to the present law. And then in Section 3, gentlemen, you also talked about everybody being able to smoke marijuana. In Initiative 69, gentlemen, does it not outline who could participate in the medical marijuana program if it, in fact, were to become law?
The types of diagnoses, is that what you're
No,
referring
sir,
to?
I'm talking about who. Who is the person that can participate in this program?
Are you talking about a patient or someone on the business
Well,
side?
that would be the patient, wouldn't it?
It would. So it would be anybody with any of those diagnoses that's listed.
And gentlemen, just so that we can understand a few of the diagnoses, so that the public would understand, I don't think that anybody in the public would want to have cancer to be able to get a marijuana brownie, or would want their children to have epilepsy or seizures, or would want to have Parkinson's disease or Huntington's disease or muscular dystrophy or multiple sclerosis or post-traumatic stress disorder or positive status for human immunodeficiency virus or debilitating pain or wasting or Crohn's disease and nausea and severe muscle spasticity, and these medical conditions, debilitating medical conditions, go on and on. Do you think there's anybody in the state of Mississippi who would want one of these medical conditions just so that they could have a medical brownie with marijuana, THC, or an oil to rub on their bodies, or a lotion to rub on their bodies? Do you think that they want that?
Lady, I would submit to you that all of those same diagnoses would also be covered under HCR 39.
No, they won't, gentlemen. They would not, because...
That's your opinion.
Well, no, gentlemen, I'll read to you what your 39 says. The program shall provide for limited categories of suitable and verified qualities of standards for oral administration. And it would be restricted to the treatment of qualified persons
But isn't that
who
what we
in
want,
fact
lady?
have terminal medical conditions. Gentlemen,
Now, that's just
would
the
you
smoking
not
side of it,
agree?
lady.
Would you not agree that a person who has Crohn's disease, or a person who has a spinal cord injury, or a person who has muscular dystrophy, are those conditions that would fit your description
I believe they
for
are.
terminal?
Lady, it's not, HCR is not limited to only terminal
I'm just reading what you got in this thing here.
Smoking. But there are edible parts of it that would not be. It's just the smoking of marijuana that would be limited to terminal patients.
And gentlemen, if you would go to Section 3, because we want to be truthful to the people, in Section 3 it says, go down to F, where it talks about, because you said that you could have a pot shop and the folks could be smoking right in front of the courthouse or somewhere like that.
Lady, where are you at? Are you in 65 or are you in HCR 39? Which one are you on?
We're debating both of them, actually.
I know, but if you would point to me to the right
I'm
one,
in 69 now, gentlemen, Section 3.
it'd be 65.
65, I'm sorry, Section
Okay.
3, where it says that any, and at any public law or ordinance or regulation or rules or private rules or regulations or provisions related to smoking in and on a public or private place, that is not acceptable. That is not provided for in this initiative. And then you also talked about us being able to pay for these people, the medical marijuana people participating in the program. Well, gentlemen, are you aware that there's not an insurance company anywhere that will pay for medical marijuana? Not in Colorado, not in California, not in Michigan, not in New York, not in Oklahoma, nowhere.
I agree.
Okay, but you're represented to this House that they be paying.
No, I certainly did
come
not.
on.
I certainly did not, lady. What I told this body, I'll let you have as much leeway as I can, but when you start putting words in my mouth and accusing me of telling this body one thing that I didn't do, I'm going to speak up, and that's not what I said. What I said is that anybody will be able to go to a doctor of their choosing to receive one of these diagnoses, and the insurance company will pay for that. Just like if I go right now and my back hurts, and I'm telling that doctor my back's been hurting for 6 months, and it keeps hurting. I go back, it keeps hurting, okay? Eventually, I'm going to be diagnosed with chronic pain. I can then take that medical record that the insurance company has paid for, those visits, that treatment, and I can go over there to my marijuana doctor, and I can get my marijuana. Okay, that's what I said.
And of course, gentlemen, you can do the same thing with the OxyContin prescription as well, right?
If you say so.
And then, gentlemen, with an OxyContin prescription, you and I and everybody in this place and all the taxpayers in Mississippi will be helping to pay for that particular drug. Isn't that correct?
Because it's properly regulated by the Food and Drug Administration.
Well, gentlemen, would you not agree that we have an opioid crisis? And since we have an opioid crisis that says that there has been improper use of this properly federally regulated drug, but once it got on the market, this federally regulated drug, through some reason, it has been misused. Is that's reasonable?
I would agree 100%.
Okay, because I just want to be clear. Now, gentlemen, I know you said you did some study and some research. I have not in all instances. Can you tell us any of the ills or any of the problems of any of the states that have implemented medical marijuana in America?
Well, my understanding, lady, is that a lot of states do it differently. So I would hate to.
Can you identify any of the problems that any of those states have had?
Which state are we referring to?
Well, if you know of any state, gentlemen, that has implemented medical marijuana, can you tell us of a problem that they have had?
I can tell you in the state of Oklahoma, I mentioned this earlier, that they did not cap the number of permits for the business side of it, and they have over 10,000 permits in the state of Oklahoma. And that cannot properly be regulated. Something similar could not properly be regulated here in the state of Mississippi.
But gentlemen, I would think you, being of the Republican persuasion, I always hear y'all talk about free market, let the free market work its will. So sure. We all know that if I get a license and I can't make my license work, then I'm going to go under, right? So apparently, if Oklahoma has 10,000 licenses, would you not agree that apparently those licensees are making their, whatever it is, if it's dispensing, if it's growing, if it's marketing, I don't know what their licenses are for, but apparently they're making it work, right?
Lady, what I'm submitting to you is it would be a wiser course for this, in policy, for this body to properly regulate and place a reasonable limit on the number of permits it gives out.
Okay, gentlemen, now you also indicated that a marijuana treatment center could be at the courthouse or anywhere. You just wake up and there they would be. In Initiative 65, in Section 8, it talks about where medical marijuana treatment centers can be located. If you would go to subsection 4, gentlemen, would you not agree that it says no medical marijuana treatment center shall be located within 500 feet of a pre-existing school, church, or licensed daycare center. And those liquor bills that you brought out yesterday and today, those people can be, they can't even be, 500 feet is where it is for the marijuana. They could actually be closer under the existing law, because I believe it's 1,500 feet, isn't it, gentlemen?
Well, lady, there is a regulation on alcohol as well, and I'll tell you, 500 feet is about a football field and a half for those people who think like I do. But what's important is that you need to continue to read. When you stop at that sentence, the provision continues as follows. Except as otherwise provided, any zoning ordinances, regulations, and/or provisions of a municipality or county shall be consistent with Section 1 of this article and shall not impair the availability of and reasonable access to medical marijuana. Zoning provisions applicable to retail dispensaries shall be no more restrictive than those for licensed retail pharmacy and zoning provisions. It goes on to state that it shall be no more restrictive than other comparably sized and staffed lawful commercial and industrial businesses. It exempts it from the local zoning ordinances.
No,
Yes, it does.
No, what it says is it shall not be any more restrictive, gentlemen. And I guess we would have to say, if a pharmacy can dispense OxyContin, and if medical marijuana were to become legal, it would have the same status in the state of Mississippi, so there would be no reason that a dispensary should be treated differently from a pharmacy. And if you will go back to 65, it tells you that all of that is only dependent upon, so that the House and America and Mississippi and the world would know, that it's only dependent upon the availability of and the safe access to medical marijuana for qualified persons, and these are people who have debilitating medical conditions. This is not for people to be getting high. Now, my last question to you, gentlemen, is about you talked a little bit about who was going to receive the taxes and all of that. And you said that the monies that were going to be generated from this initiative, if it were to become law by the citizens of the state of Mississippi, would not come to us. But would you not agree that it only outlines 3 areas where dollars can be received by the health department if this becomes the law? Is that not correct?
I said what I said, lady, and the document reads the way it reads.
Okay,
I'll stand by that.
Okay, go ahead and tell the House what those 3 areas are.
I'm going to let you do that,
Well, gentlemen.
because I'm not sure I follow you.
Well, gentlemen, you stated to the House that if the initiative that was introduced by the people, 200,000+ people who had signed the petition, you said that they had in this language kept this House and the Senate from appropriating their proceeds from the sale of medical marijuana. Is that not what you said, gentlemen?
I did. You can look at Section 6, and Section 6 speaks for itself.
Okay, but that's what you said, right?
Lady, I stated that this body would not be allowed to control the taxation, nor appropriate any funds derived therefrom. That's what I said.
Okay, but actually what the initiative does, the initiative provides for, and I think that those of us who like to see things pay for itself would support this. It talks about 3 sources of operating revenue for the State Department of Health. This is to use in implementing and enforcing the provisions of the amendment. So would you not agree that the first source is a fee for identification cards? Sure. A fee for identification cards. Then there would be a fee set for treatment center licenses.
No more than $50.
Okay. And then the Department of Health may access at the point of retail sale for medical marijuana. But it says that they shall do the first two, and they may do the third one. Is that not correct?
That's what it says. Also states that the revenue generated under this section through the issuance of those ID cards and the licensing of medical marijuana business facilities shall pay for the costs incurred by the department in implementing and enforcing the provisions of this article, and shall be deposited into a special fund in the state treasury to be expended by the department without prior appropriation or authorization. That's key language.
Okay.
Totally removes it from the legislative process.
And we have done that before, because we just did that the other day for MDA. But
You know, lady, I haven't passed an MDA bill this year other than just bringing the code sections forward, so I really don't know. You keep
Okay.
saying that, but I'm not sure what you're talking about.
all right, well, I'll show it to you after we get through.
Okay.
Based on those calculations, as we continue to read, it says that it would only generate $6 million. And that $6 million would be to keep you from being concerned about the health department being able to hire the number of people that they would need to regulate this particular initiative if it were to become law. Isn't that correct, gentlemen?
Lady, I'm not sure where you get the $6 million from, but I'm trying to follow you.
Well, I'm getting my information just like you get yours, gentlemen. But I was told that it would be $6 million.
Okay.
Okay, so if the only reason I asked you those questions and said that to you is because you kept telling the House that this was an overreach. This was an overreach.
I stand by that.
But do you not think that that it is a good thing that the citizens are involved in the initiative process?
Lady, if it wasn't a good thing, then we wouldn't have that law. That's why the law exists.
Well, and so since we both agreed that it is a good thing, do you think that, well, you said that you didn't think that the people who signed the petition knew exactly what they were signing. Do you have any kind of empirical evidence that you could present to the House to let us know that that assumption or presumption of yours is based in fact?
Lady, what I said was that I believe most people who sign the petition are in favor of a medical marijuana program. And what I said next was I don't believe most of those people are in favor of a medical marijuana program that you can't tax and will provide no funds to this state, that goes under our Constitution, that exempts all the business aspects from local zoning ordinances, that goes on and on and on and on, all the things I've been talking about for well over an hour now. And I don't believe they do that. And the evidence I can cite to you is that every single person I've talked to that's in favor of, and I'm sure there's some exceptions, but that's in favor of a medical marijuana program, had no idea that the language that's going to go into the Constitution actually read that way.
Would those people that you talked with, did they have any idea that the alternative that you're proposing would restrict people who have cancer that are not dying, that have epilepsy who's not terminal, who has Parkinson's disease who's not dying, who has Huntington's disease or muscular dystrophy or multiple sclerosis or on diseases that are not at a terminal stage from being able to access the medical marijuana treatment if your alternative were to become law? Was that explained to them?
Lady, I believe it does. I believe it provides for an adequate medical marijuana program in this state, and I've stated that multiple times.
And that there is no restriction, even though it's in the language that there's a restriction?
Lady, what it states is, it states that the smoking of marijuana products will be restricted to the treatment of qualified persons who have a terminal medical condition as established by their physicians.
But gentlemen,
okay? There is also in here language that provides for other forms of marijuana, and that is not limited to terminally ill patients. Okay, so I want to be very clear about that.
Are you talking about 39 now, gentlemen?
Yes.
Okay, will you read that to the House?
Lady, I just did. I'm telling you, that's
No,
what it
can you read,
does.
tell us the line where that's located in your bill, in your
Lines
resolution?
54 through 57.
Okay, gentlemen, now, you said that it was not limited to smoking. Where in this resolution does it says that a person can get oil, can get ointments, that they can get food products? Where in this resolution does it say that?
Lady, it will be regulated by proper physicians and medical personnel. I'm
Just
telling
like
you
in
that.
65? Because 65
No.
gives the health department the authority to promulgate rules and regulations.
Lady, for the reasons I've already said, 65 does not and will not provide for the proper regulation of that system.
Okay, thank you, gentlemen.
Thank you.
Are there any further questions? Gentleman from Fayette.
Three quick questions. I'm new to all this, and these aren't heated questions. I would like to point out that my son is here, and I'm against medical marijuana. I'm against marijuana in general. So I'm just trying to find my way through all this, just like you.
I will yield to you, gentlemen.
Thank you, sir. The first question is government regulation has been involved in opiates forever. We all have friends and family members that have been ruined from government-regulated opiates. So I'm just trying to figure out, I'm trying to be sold on the idea of us regulating this being different. If you could please tell me how we're gonna regulate marijuana in a different way than we have opiates.
Are you talking about HCR39? Is that right?
That's right.
Okay.
Your answer to regulation and their answer to regulation is both going to be regulated unless we choose to.
Well, gentlemen, for one, this HCR39 provides for a limited number of licenses. You know, you're not going to have as I said earlier, every Tom, Dick, and Harry wanting to set up a, marijuana farm in their backyard. And so therefore, by capping the number of licenses, then by definition, it makes it manageable under the Department of Health. Our Department of Health is not the FDA. They're never going to be the FDA. They're incapable of doing that. They don't have the funding to do that, the staff to do that. So we've got to make it reasonable such that it can be properly regulated.
The second question is if we are going to why could we not just avoid this altogether by following the federal statutes that are in place?
Well, gentlemen, we have a law on the books in this state that allows the citizens to present an initiative such as the gentleman has done, and he took advantage of that. The people signed the books, they signed the petition, and you're going to vote on it come November whether you want to or not. It's going to be on the ballot.
And at this point, we know it's going to be on the ballot, whether we want it on the ballot or not. And if we believe that the majority of the state is opposed to medical marijuana, why don't we leave it at just that and have a yes or no vote?
Well, gentlemen, I would tell you that there is other thought that the majority of the state is not opposed to medical marijuana, and if we're going to have a program, we need to have a proper program.
And you're saying the government-regulated program is going to be superior to a board of private individuals, doctors, physicians, and I don't know the answer.
Then a gateway to straight recreational use, yes, I'm saying that.
All right, fair enough.
Thank you.
Lady from Hines, Ms. Clark, do you have a question?
Thank you, Mr. Speaker.
Yes, ma'am.
Would the gentleman yield?
Yes, ma'am.
I'd like to, thank you all for letting this come out, because most everybody here know that this is something that I've been struggling with. I don't know if you know it or not, but most of these other people who've been here for a year know that before I came to the legislature, I was diagnosed with multiple sclerosis. But when you say that, in here it says that people who are terminally ill, I want to know, would 39 do me any, would it be good for anybody with MS? That's what I tried to find.
Lady, I believe it would. I believe it would. Lines 45 through 47 and 39 states that marijuana products that are used by qualified persons in the program shall be of a suitable pharmaceutical quality and prepared by states licensed manufacturers. That's going to be left up to your physicians. It just says the smoking of marijuana is limited to terminally ill patients. And so I had to learn all this too, but there are all sorts of different forms of marijuana. Edible is a big part of that. There are lotions and oils and things of that nature, but my understanding and my belief is yes. Should 39 pass, then you will have a medical marijuana program that will offer the types of services to someone such as you that you could take advantage of if your physician believes that's good for you.
Would it not be better if we had where it was actually named and not if they were?
Well, lady, I believe it is named. I believe it is. I believe the language of HCR39 states that.
You believe it is,
Yes.
but we just don't know exactly
Well,
where.
the only limitation in the language is the smoking of marijuana. That's the only limitation. It says for all other products, they'll be properly regulated by physicians and healthcare professionals.
I know you are aware that there are some medical problems that some people have where they hurt every day.
Yes, ma'am.
And they would be so much better off if they just had just a little relief.
I understand.
Okay. Well, thank you very much.
Thank you.
All right, I don't see any further questions. I'm going to recognize the gentleman from Madison, Mr. Bumgar, who wishes to speak on the bill. Gentleman's recognized.
Thank you, Mr. Speaker. Ladies and gentlemen of the House, well, first of all, I have no business interest in cannabis. I never have held cannabis stock. I don't plan to. That is not my deal. So why am I so passionate about this issue? I'm passionate about this issue for 3 reasons. One, I lost both my parents to cancer. My mom died when I was a senior in college in 2002. I was 22 years old. And my dad passed away when I was 2006. In 2006, 4 years later, when I was 26. And both of my parents died from the kind of cancer that takes over your body, shuts it down, and you die in an extraordinary amount of pain over years or months or however long that process goes. And they had chemotherapy, they had opioids, they had all of that stuff, and they died in extreme pain. I remember my dad telling me that every day he woke up and his question for the day was, will I be able to stay on top of the pain today? After my parents passed away, I was talking to some of the cancer doctors that were involved in their treatment, and they told me that medical marijuana would have really helped my parents, but that they were not even allowed to tell them about it because we live in the state of Mississippi. And of course, my parents, I've never used any illegal substance in my entire life, neither have my parents. That was not something we would have even considered. And so people in Mississippi are dying in way more pain than is necessary because 34 states have done something that we have not decided to do. This is an opportunity to do the right thing. So I'm passionate about this topic because my parents are buried right here in the state of Mississippi in Clinton Cemetery, just a few miles from here. And they could have died in a lot less pain. Secondly, Harper Grace, the little girl that Harper Grace's law is named after, when the program was created for her in 2004, she never got to participate in her own program. After 6 years, there are only 8 people in that program, and her parents were told that she couldn't participate because she was not having enough seizures per day. And the only way to get part of the program was to go off all of her other seizure medications to try to get her number of seizures to go up so that she would meet the baseline to qualify for her own program. So Harper Grace's program doesn't even have Harper Grace in it. How unconscionable is that, ladies and gentlemen? We've had a chance to create a medical marijuana program, and that's what we created. And that program is so small and helps so few people, it's almost non-existent. And there's no reason to believe that this would be any different. Additionally, ladies and gentlemen, I'm passionate about this topic because states that allow medical marijuana have about a 25% lower opioid overdose death rate as compared to states that don't allow medical marijuana. So Mississippi is the 4th highest prescriber of opioids in the country. And as I talk to doctors, they say, look, I don't want to be giving people all these opioids. I've got the Mississippi Bureau of Narcotics breathing down my neck, telling me prescribe less opioids, and I've got the Mississippi legislature telling me I'm not allowed to use medical marijuana. What am I supposed to do? What a rock and a hard place we have put them in. Ladies and gentlemen, there's no reason, again, to believe that the program that would be created if HCR39 became the law would serve any more than 10 people. But it doesn't even matter because HCR39 was never intended to create a program, ladies and gentlemen. HCR39 was intended to kill medical marijuana in Mississippi. It's absolutely intended to kill it. Let's not play games. Look, there was no straight answer to my question of were there discussions in the group behind this about killing both initiatives. Of course there were, because that was the intent. And if you don't believe that was the intent, look over here on this board to my right, your left over here. It includes the ballot title of both initiatives. Now, ladies and gentlemen, I would be shocked if anyone in this room, including the gentleman from Tate, could tell me which one is Initiative 65 and which one is HCR 39. And you know why? Because they're basically photocopies of each other. The intent of HCR 39 was to put an alternative on the ballot that would split the vote. And the threshold that's required is you have to have a majority of the vote yes, but then the winning alternative, if there's 2 of them, has to be above 40% of the vote. When you have 2 alternatives on the ballot, it makes it almost impossible to clear that 40% threshold. The gentleman from Tate knows the math. HCR 39 is an intent to kill both. And if it wasn't, then the ballot titles would not be an exact photocopy of each other. You couldn't, not for the life of you, figure out which one's which, because they're intended to be identical, to split the vote right down the middle, so one of them gets 30-some%, the other gets 30-some%, and they both die. That is the intent. Split the vote, kill both initiatives, which hurts people like this, ladies and gentlemen. And we don't have to do this. We don't have to do this. There's no reason we should be in here voting on medical marijuana. I have talked to every single one of you multiple times over the last 5 years asking about medical marijuana and can we do something about it in this chamber. And the virtual universal answer I got was, let's not do this in this legislature. That's something that the people should decide. Well, 228,000 people finally said, okay, if the legislature, if they're consistently telling me, let's not do this, I don't want to do this, let's please not do this, let's not vote, we shouldn't vote, let's not vote on this, and we put it on the ballot, and suddenly, oh, we're going to vote on this. Ladies and gentlemen, let's be honest here. If we intended to set up a medical marijuana program in Mississippi, we would have done it already. It would not have taken 228,000 people to do that. So ladies and gentlemen, this is an effort to kill. By splitting the vote, it hurts people like this, and there's no reason to believe that the program that would get created by HCR 39, which will never pass, HCR 39 will never become law because it's not intended to become law, because there's no way it would result in more votes. So, ladies and gentlemen, I'm going to ask that you would support a motion to table to make this go away. And if it's called in favor of against, I would ask that you stand with me and let's go to the board on a motion to table. And if that doesn't prevail, I would ask that you vote no on the amendment. We do not have to vote on this. It's already on the ballot. There is no reason for us to split the vote. All I'm asking is that the people of Mississippi have a fair up or down vote in November. That's all I'm asking, a fair up or down vote in November. Please support a motion to table. Mr. Speaker, I move to table.
Gentlemen, council informs me we've already moved on to final passage. Motion table is not in order. So time has passed for that. All right, I recognize, Gentleman Madison, what purpose you seek recognition? You're recognized to speak.
I was wondering and I guess pondering whether I would even get up here and speak. I listened to the debate and I said, maybe I should say something. Now, as a father of 3 sons, I've debated this many times. I promise you, I've did more than debate. I've begged and done everything else in opposition to marijuana. I don't know if I was successful or not, but I think my sons made it through it. But this has to be with a personal story. The gentleman from Madison talked to me too this summer. And I think I told him, you know, I'm not really for marijuana smoking. And for that reason, I didn't join with him. And I told him I don't even think I can even vote for it. But I think I've changed my mind just today. I would vote for it for the reason that the lady from Jones, her questions about the benefits of it for those people who would use it for medical purposes. I think I've been thinking a little warp-sided. I didn't think in that direction. I was thinking about the recreational part of it. But then I thought about what happened to me. When I grew up, I was born with a respiratory problem. Serious. I was skinny, scrawny, gasping for breath during the winter months, but nowhere to go. They didn't have albuterol. They didn't have the mist, the dispensers that they have now. I had 0. My remedy was this. When I couldn't breathe, my mother took me to the front porch at night and let me stay out there. That's a tough way to live. I'm a little emotional now because it brought it home. You know how I finally got relief? My mother took me to my great aunt. She put me in a room and she got a gold chalice and she put opium in it and lit it up and closed the door. After a couple hours, I could breathe. Later, it became illegal to do that. But without that, I don't know if I'd have made it. These people need help from us. This amendment, regardless of the good intent, will challenge that. In our state, when you have a referendum, citizen referendum on the ballot, it takes a majority of the vote. It takes 40% of the people voting to vote in that majority. If you have something to debate that, to give an alternative, it can split the vote. That's not a good thing. So if we really want to help people, like the people who've been described in the referendum, you want to help people like me when I couldn't do any better, whose life was probably saved by the drug that you can't use now. I know what it feels like to have the life being choked out of you and not having anywhere to go, any help anywhere. Can you imagine these people who are suffering right now, who want nothing more than get some relief? Not to be made well, but to survive the next minute. We have an opportunity to do that. And up until this debate, I probably would have gone in and voted against it because I identified it as marijuana, not as a drug that could help people. Forgetting my own trials and tribulations with a drug just like marijuana was back in those days. I'm going to vote to try to help some people if I can. I know that this bill, and I'm not criticizing anybody who brought it forward. I don't want to question anybody's intent, but I'll tell you what the result will be. we'll have, if we pass it, we'll have 2 bills addressing marijuana on the ballot. To have success, one of those bills will need to have 50% of the people voting, the majority of people voting, and 40% of those people voting for it. If we really want to take a serious shot at helping these people who cannot help themselves, those people who are like me, those people who look for any relief possible, a pat on the back, sometimes is all I got. I've been selfish, thinking only in one direction. I've changed my mind. I want to help somebody now. I'm going to vote for the gentleman from Madison's effort and try to help somebody who needs help. After all, now think about it, that's why I was elected. That's why we serve. That's what we're here for. We can debate all of the regulations that may come and go, but I know this, not as a constitutional scholar, but just plain old everyday sense, that we in this body every year pass enabling legislation. We don't think about the Constitution that allows us to do that. When somebody raises the issue, it's not whether it was constitutional, we always say, well, we don't pass on the constitutionality of our legislation. When this resolution, hopefully this initiative becomes law, it'll be our job to pass enabling legislation. I will guarantee you that we'll have a shot at making sure all of the evils that have been expressed here that are seen in the initiative will be addressed in this body. There will not be one single dispensed marijuana drug when this referendum becomes law that would not have passed by legislation in this House. I know that. We shouldn't pass a competing measure that might stand a chance of dividing the vote and deny people who are suffering right now, who need our help, and they need our help badly. Why would you, well, I'm old enough now to have seen a lot of loved ones pass on. I've been there with them. I watched them in pain. And when they pass, you know what we say? At least they're not in pain now. We shouldn't have to say that anymore. For any of our loved ones, or any of our citizens, thank you.
All right, I recognize the author to close on the bill, resolution.
I applaud the gentleman's talents. Did a good job. I applaud him. It's not a fun spot to be in. The gentleman knows how to talk to a jury, knows how to move a body. Again, I applaud him. So do I. Let me tell you some things. I didn't intend on going here, but since the gentleman from Madison got up here with fancy posters, and the other gentleman from Madison talked about his childhood, let me tell you all a story. 2011, I had just qualified to run for this body. My father was diagnosed with stage 4 non-Hodgkin's lymphoma. A lot of y'all don't know that. Stage 4. Not just my father is my senior law partner. I seriously contemplating pulling my name out of the hat to run. He wouldn't let me do that. I've seen what someone goes through to go through serious cancer treatments. Praise God, my father's here today. He's still my senior law partner. But there was a time, you know, we never know what the future holds, but it certainly was in doubt, albeit in God's hands. Fast forward a few years later, 2015. 2015, I sat right back there in that seat, opening day of the session, raised my hand to take my oath, just like all of you who were here at the time did. Within 15 seconds of taking that oath, I got a phone call from my wife that my mother-in-law had just passed. For the several months leading up to that, she was on her deathbed with pancreatic cancer. I've seen it, gentlemen and ladies. I'm not oblivious to the things you're talking about, gentlemen and gentlemen. I am for a medical marijuana program. If legitimate marijuana drugs would have helped my father and my mother-in-law in those situations, I'm all for it. What I'm not for is a ruse that has been shaded on this state under the guise, the proposal of a legitimate medical marijuana program. Initiative 65 is not that. There's a reason the gentleman does not want everybody to know the language that will actually go into the Constitution. And I'm telling you, I'm for it. I see the benefits of it. If the gentleman had not overreached so mightily, we would not be here at this hour, at this time, to vote on what I feel is a legitimate medical marijuana program, HCR 39. If the gentleman would have used the language from HCR 39, we wouldn't need an amendment. I can't undo the past, and every one of y'all know it. We're here because of the language that he proposed to be put in our Constitution. For all the reasons I've stated to you today, it is not best for this state to go forward with Initiative 65. I will not be voting for Initiative 65. I will be voting for HCR 39 because I believe it is a legitimate medical marijuana program that can be beneficial to the citizens of this state. And I would ask you to support its passage here today.
Before we vote, gentleman from Madison raised a point of order regarding the vote requirement. Council has referred me to Section 273 of the Constitution. It says an initiative may be adopted by a majority vote of the legislature. That is also codified in 2317-29, according to council. So the vote is a majority vote. Question now, point of order is not well taken. Question now recurs on HCR 39. Open the machine, Madam Clerk. If you favor the resolution, vote aye. If you're opposed, vote nay. Has everyone voted? Has everyone voted? Close machine, Madam Clerk. By a vote of 71 yeas, 49 nays, resolution is adopted. Announcements, Mr. Clerk. Announcements, Madam Clerk.
The Rules Committee will meet at 1:15 in room, at 2 in room 302.
Anything before lunch? Gentleman Jackson, Mr. Reed.
Mr. Speaker, are we coming reconvening after?
Yes, sir. 2 o'clock.
Okay.
Be my suggestion. That it? Okay. Lady from Jones, Ms. Scott.
The whole House concurrent resolution 39 on a motion to reconsider.
Okay, we can do that.
Thank you.
Chairman of Rules, we're going to come whenever you're ready, gentlemen. We'll go to lunch.
What's that?
We're going to come back at 2 o'clock. You want to have a rules meeting, you need to reschedule that time.
We'll schedule a rules meeting for 1:45.
1:45. All right. Recognize the gentleman for the motion.
Mr. Speaker, I move this House stand in recess until 2 p.m.
You've heard the motion. All in favor say aye. Opposed, nay. Ayes have it. House in recess till 2 p.m.